So, we'll discuss the very capacity of a Muslim to make the gift or hiba. So, one of the main capacity is the mental capacity, and which we found as every Muslim, male or female, married or unmarried, who has attained the age of majority and who is of sound mind has the mental capacity to make a gift. It appears to be clear that under Muslim law, for the purpose of making a gift, the age of majority is attainment of 18 years. The rule of Muslim law of majority attainment of puberty does not apply to gifts. Here, only the Indian Majority Act 1875 is applied, and now we'll discuss a leading case regarding the mental capacity of a Muslim to make gift, and in that connection we'll discuss the leading case Hussaini Bai versus Zohra Bai in 1960. The Madhya Pradesh High Court explained that a Parda Asin Muslim lady was brought from Nagpur to Berhampur on the pretext that her brother-in-law was seriously ill. At Berhampur, she had a fit of hysteria, and soon after it she was made to sign the gift deed without affording her any opportunity of taking independent advice and without informing her as to what were the contents of the document. So, the High Court of Madhya Pradesh held that gift deed was not executed from the lady under any independent circumstances, but under compulsion. It was so not her voluntary consent or act, and therefore the deed was held valid. And regarding the financial capacity, we will discuss the views of Amir Ali and the views of the Malikis school and the Hanafi school. So, regarding that, the financial capacity, the Malikis hold the view that a person under insolvent circumstances or extremely involved circumstances has no capacity to make a gift. On the other hand, the Hanafis hold the view that insolvency does not create an incapacity to make a gift. The Indian courts follow the Hanafi view. However, in every gift there must be a bona fide intention on the part of the donor to transfer property to the donee. Obviously, if a gift is made with an intention to defraud the creditors, the gift is invalid. So, these two capacities are the most important capacity regarding mental and financial capacity to make gift. And now we'll go to the very subject matter of gift. And regarding subject matter of gift, all forms of property over which the dominion could be exercised or anything which could be taken into possession, which could exist as a specific entity or as an enforceable right, may be the subject matter of a valid gift. Muslim law in this context makes no distinction between ancestral or self-acquired In fact, there is no such distinction in Muslim law or between movable and immovable property, a hiba or gift to be made of the entire property, but it should be noted that a Muslim can bequeath by will only one third of his property as it was held in the leading case, that is Lala versus Rasulullah in 1957 by the Jammu Kashmir High Court. And our next is that Muslim law in modern India, the incorporeal property can be as much the subject matter of gift as the corporeal property. Thus, negotiable instruments, government promissory notes, Malikana rights or the Jamindari rights can be subject matter of valid gift as it was held in the leading case Malik Abdul Ghaffur versus Mulika in 1884 by the Calcutta High Court. So, Muslim also a similar gift can also be made of the property on lease as it was held in Anwari versus Nizamuddin in 1898 by the Allahabad High Court. So also property under attachment or right to receive specific share in the offerings that may be made by pilgrims at a shrine could be a subject matter of gift as it was held in Iqbal and Controller of Estate Duty in 1964 by the Gujarat High Court. So also in the Maqbul Alam versus Khadija in 1966 by the Supreme Court. So exactly in the Fatwa-i Alamgiri, it was held that a gift of something which is not in existence at the time of conduct will not be valid. And in the leading case, Maqdul Alam versus Hudeja, in the Supreme Court said that the gift of the property in possession of a transfer cannot be made merely by a declaration on the part of the donor and acceptance on the part of the donee. Such a gift will be valid only when the donor puts the donee into possession or put the property within the power of the donee to obtain possession. So also the assignment of an insurance policy by any person is statutorily permitted in India, which could also fall under the very subject matter of a gift. And